the jurisdiction first.
Right, which one do you think? So the payments first figure will go with 1 and 2 only.
Jurisdiction
Right.
and the national government.
Right.
Why isn't the claimant not wanting to address?
I think that's just how they prepare this.
Okay.
So they can't prepare it.
Yes.
Got it.
And since they haven't taken up issue 3 right now, it won't be fair for us to rebut them on that.
Yes.
So we will only give the buttons for issue 1 and 2, and they can answer that with their search buttons.
Okay.
Then they will proceed with 3, 4, 5.
Okay.
We will respond with our submissions as I will be sent to the court and try it.
Okay.
And then since I'm the one who gave the last argument,
Yeah.
they will ask me rebuttals for 3, 4, 5, and I'll give them the search. This is the first mechanism that we're proposing. The second mechanism is the mechanism.
Do you think it's more feasible for the claimants to raise the merits of the case first? So what I'm proposed is that the respondent goes first on jurisdiction, and then the claimant responds on jurisdiction. But then the claimant goes on to they go on to present the merits of the case.
That's where addressing issue 3.
2 and 3.
2 and 3.
Yes. And then the respondent can respond on the merits of the case by presenting his way after. And then you can do a full rebuttal, on issues 1, 2.
The only slight problem is that my co-counsel will have to split his speech. So instead of saying 1, 2, 3, I'm going to prepare the time allocation. Only know with 1, then my opposite counsel will get the.
Well, are you all okay with the not rebutting of time? Should we agree to what they propose?
You agree? You agree? You cannot. But they are uncomfortable. You responded for the issue.
They're supposed to respond to the merits that he presents.
Right, but we make sure that we're responding to the merits that they propose in the and we make sure that we only ask rebuttals for the issues that they've already raised. We do not ask rebuttals for issues since they have not raised that. It's fair to the case to be raised.
So if we do this, now the jurisdictional objection,
Right,
you're taking it up,
right,
right? You take it up first.
yes,
They address it,
right,
right? Then the jurisdiction is done.
yeah,
Then should not, I think in conventional sense, may present their claim,
yes,
and you rebut the claim.
exactly, right.
Isn't that what we should do? I don't know.
So, can we go with the proposed model of RCR, that is, my co-counsel goes first to jurisdiction issues.
One is jurisdiction.
2 and 3 are the merits.
That's
The
right.
claimant should go
Yes.
first.
So if you have one with R1 addressing 1, then claimant rebutting that. So can we
Jurisdiction's done.
done? That's what we think, right?
Actually, in what they're proposing, we go first with the jurisdiction issue, and then they continue with the jurisdiction and also attach to that. They're going to say 1, 2, 3, and in that manner, my co-counsel's speech gets split, and I have a gets an
So you want to rebut
Jurisdiction.
and address 2 and 3.
Raising.
So can't you limit it to jurisdiction alone?
You can just record.
Yeah.
The problem is time.
Yeah. So I don't know how we can resolve that.
But, Mr. President, I may reason our allocation. It is because after we rebut after we respond on jurisdiction, you would nevertheless need to bring the merits of the claim to this tribunal,
Yeah.
which is why we are continuous with presenting
It
issues.
makes sense.
Yes, Mr. Arbitrator, but in the mechanism that we're proposing, to be fair, because this way, they answer only one issue, and we get to answer.
Damage is not, yeah, that's it. We can, but no, we can't, we don't want to make a decision which cuts across their direction. So we will have to ultimately resolve, this is your competition. You will find a way out there.
We're making sure that since the claimants, they get.
They are okay with anything, I think, they are okay.
It doesn't matter to us, we are here to disagree with us.
Yeah.
Actually, in the mechanism that was proposed, it's for the convenience of the people, all 5 issues going on.
So we shall be amenable to your.
Thank you so much.
Okay, all right, thank you very much.
Thank
Have a good day.
Thank you.
So do you need to give the proposal to Mary?
Can I get the time allocation?
Right. So my co-counsel will be doing this first speaker for issues 1, 2, and 3. And we'll be taking.
I'll be taking 16 minutes for my submissions and 1 minute to answer certain questions.
Then the claimant's first speaker will be.
I'll take 12 minutes for my submissions, 1 minute for the
Excuse me, 12 minutes for issue
1 and 2.
1 and 2.
One and
Okay.
Then claimant's second speaker will continue.
Yes, I'll be taking 15 minutes for my submissions and 2 minutes for rebuttal. Thank you.
Then I'll be going for issues 4 and 5. I'll take 11 minutes for my speech. And I'll reserve 2 minutes for answering the rebuttals. That's the service.
Before the can I get your first name, Shreya?
My name is Roshan Potaranchu.
Thank you.
Anaka Rastu.
Kevin Singh.
Benedict too.
Yeah. So who is speaking first from the respondent, R1 or R2?
That's you. So R1, C1, C2, R2.
R, yeah. Okay. Okay, so on behalf of the tribunal, we wish all of your very best, and we will interrupt you to ask questions. So we hope you all will be on the board. First, it's all the very best.
Greetings, members of the tribunal. My name is Roshan, and I, alongside my co-counsel Anka, will be addressing you and representing the respondents of this dispute today. I will be addressing you on issues 1, 2, and 3. To provide the tribunal with a bit of background on this dispute, I would like to point out that our respondent has, over the last few years, taken many steps to overhaul their healthcare facilities. It is with this intention to ensure equitable healthcare for all that the claimant was approached for an investment agreement. However, despite the claimant's supposed commitments towards providing affordable healthcare, they blatantly violated many of the regulations put forth by our respondent to ensure that all of the needy individuals in Equatorial have access to life-saving medicine. As it stands today, over 3 million citizens of Equatorial are currently deprived of even the most basic medicines because of the claimant's actions. With this, I will be beginning with my submissions for the first issue of this dispute. Here, I take a primary claim that in the absence of any dispute resolution clause in the investment agreement, the claim should have been brought to the local courts of Equatorial. We have one major objection to making jurisdiction in this regard, and that is, due to the non-compliance with Equatorial's host state laws, this tribunal would lack the jurisdiction. Here, if I have the tribunal's attention, I would like to point out to Article 5 of the BIT, which can be found on page 14, Annexure A. If the tribunal is with me. If the tribunal is with me, I'd like to point out. Certainly. If the tribunal is with me, I'd like to point out this article makes it very explicit that investors and their investments shall comply with the laws and regulations of the host state. If an investment does not comply with the local laws of a host country, that country's consent to arbitration should never be presumed. In the present dispute, the claimant, that is Farmanex, has violated the provisions of the Health Care Act this is undisputed. They did this by engaging in firstly discriminatory pricing and violating the Health Equity Act's fair price mechanisms. Secondly, they violated the quotas prescribed by the Health and Equity Act. Given the illegality of their investment, the consent of our respondent to approach this tribunal cannot be presumed, and hence we put forth that this tribunal does not have the jurisdiction over this dispute. This will conclude my submissions for the first issue with regarding to jurisdiction, and I'd like to invite any questions or clarifications in this regard.
I have one question, counsel. So do you think that they did not follow the law from the very beginning, or after the investment was started? At one point, they violated the whole state law.
To clarify, the host state law that we're talking about, that is the Health and Equity Act, came 1 year after the investment agreement, and it is upon the immediate provision of this act that there was contravention seen by the claimant. I hope that answers Madam Arbitrator's question. With this, if there aren't further questions, I'll be moving to my submissions with regards to the second issue of this dispute. Here, the primary claim I'm putting forth is that the application of the HEA to Farmanex is not discriminatory and hence cannot be a breach of Article 1 of the BIT. Article 1 of the BIT ensures that the treatment accorded by member states to the foreign investors is in accordance with the national treatment standard. Here I put forth that this standard has been maintained, and I'm putting this on 3 fronts. Firstly, the claimant is not in like circumstances to its local investors. Secondly, the respondent has not accorded any unfavorable treatment to the claimant. And very importantly, thirdly, the respondent does have a reasonable justification for all of their actions that have been put forth. Coming to my first submission, that being in regards to like circumstances, I will highlight that if circumstances are not alike, no obligation arises on the part of the host state to grant national treatment. Over here, I must put forth that this merely being in the same sector, business or economic, is never sufficient to establish that there exists like circumstances. In this situation, where there is such a vast difference in the economic size of the claimant and the other domestic investors, there is such a differentiation that like circumstances cannot be established. For this, I would like to point out that the claimant is one of the largest MNCs operating in the pharmaceutical market. Furthermore, they hold a monopoly control over it. It has been pointed in the facts that they hold a market share of over 25%. In comparison, the domestic investors of this industry constitute a small-scale local companies that can simply not compete on an economic scale to the claimant. These local companies cater to only specific regional or very niche needs. Therefore, I've established that despite being in the same business sector or in the same economic sector, given the vast difference in the scale of operations, these two investors are very different in circumstances and cannot be said to be alike. Over here, alternatively, I'd like to move to my second submission for this issue, wherein I put forth that the respondent has not accorded any less favorable treatment to the claimant's investment. To this, I would like to direct the members of the tribunal to Annexure B of the moot proposition, which contains the provisions of the Health and Equity Act.
Counsel, can I interrupt you?
Sure.
Now, how the claimant relies on the case of Abbas, and where the contracting dispute did not expressly refer to an arbitration clause. How do you address that?
Certainly, Mr. Arbitrator, even if there was no representation to a dispute resolution clause, my main objection that I'm putting forth in jurisdiction is that the investment was illegal and did not comply with the provisions of the BIT. Since it is not complied with the provisions of the BIT, our host states, the respondents, consent to the application of the BIT with regards to the dispute resolution should not be presumed. That was my primary submission in terms of jurisdiction.
Just clarification, which means that you did not consent for illegal investment.
Yes, certainly.
However, you have taken the benefit of the investment.
Mr. Arbitrator, through subsequent submissions, I will point to you, there has been no benefit gained through Equiterra through this investment. All what Equiterra's agenda was in approaching the claimant was to ensure that the members of its rural family would have access to life-saving medicines. And as we have pointed out to you, that has not been the case here. Therefore, the primary agenda with which the investment agreement was signed was not fulfilled. In this context, it cannot be said that the respondent has received any benefit. I do hope that answers the question of the tribunal.
Yes.
Proceeding forward to my submission, pointing to Annexure D, that is the Health and Equity Act, it is very clear that there has been no distinction between any of the investors working within the pharmaceutical industry. This Health and Equity Act applies uniformly to all such investors. Therefore, this requirement cannot be termed to be discriminatory in any sense of the word. Furthermore, I'd like to point out that the host state has the sovereign right to legislate on matters of public importance. This gives the host state's laws a presumption of validity. If the claimant wants to come forth and tell us that the host state's laws are arbitrary or discriminatory, it should be required onto them to prove that there have been disproportionate damages that have been accorded to them. In this regard, I must point tribunal to the fact that this was a, I'm so sorry, could you a few moments of the tribunal's time? I would like to point the tribunal to clarification 82 that can be found in procedural order 2. This is on page 40. If the tribunal is with me, over here it is made very clear that despite everything, Pharmanex from the get-go of its operation in this country has been a profitable company. They have not incurred any losses. Insofar as we have put forth to you that our legislation has a presumption of validity, the claimants cannot come here and tell you that this is a discriminatory legislation if they're not proving that they have faced any damages. With this, I'll be moving to my last submission of the second issue, that being that the respondent's action has a reasonable justification. We're proving this to you on 3 fronts. Firstly, that there was a bona fide public purpose. Secondly, that this measure was necessary to achieve this bona fide public purpose. And thirdly, that it was not excessive in any sense of the word. The price controls and the quotas implemented through the HEA had the public purpose of ensuring there was equitable access to all essential medicines to all residents of Equiterra, particularly in rural areas. These are incredibly important to maintain the affordability of the medicines. Specifically in context to the respondent, this is a country that has long struggled with income disparity between rural and urban areas. Therefore, these measures were very much directly aligned to the purpose of ensuring that rural individuals had access to these medicines. Furthermore, I must point the tribunal to the fact that the HEA's fair price mechanisms are only applied with regards to essential medicines and no other medicines apart from them. Therefore, the proportionality requirement that is needed to be proven by the respondent has been established. Given paucity of time, I will be moving to my third issue of the
I will
dispute.
interrupt you at this juncture. Now, the claimant's position is that the HE is discriminatory to the claimant because though it's not specifically identifying the claimant, you are targeting the quotas of the claimant. And indirectly, you have affected the claimant and discriminated the claimant.
Mr. Arbitrator, I do understand your concern, but again, here I would like to reiterate, these quotas have been uniformly applied to all investors in this country. Furthermore, it has been proven through the clarifications that there is no other investor over here that has a dispute with the government with regards to the HEA. Furthermore, I must point the tribunal to the fact that the claimant is a very world-renowned company. They have massive amounts of resources. They were hailed by the WHO for their merits in terms of distribution in terms of their distribution in developing countries. Therefore, with regards to resources, they should have been on a better playing field than our local investors. It is because of their personal vested interest to preserve their profits, despite their commitments to not have any such interest, that they were not able to comply with the quotas. I hope that answers the question.
Yeah.
With this, I will be moving to my submissions of the last issue that I will be addressing, that is issue 3. Over here, I am putting forth that the application of the HEA to Farmanex is not arbitrary and hence cannot be a breach of the FET standards of the BIT. Over here, I have two main arguments. Firstly, that the respondent has not disregarded the investor's legitimate expectations in any way, shape, or form. Secondly, the respondent has not taken unreasonable or discriminatory measures against the claimant. Coming to my first submission, that is in terms of legitimate expectations, I must put forth that investors' expectations of regularity in terms of laws must be reasonable in light of a host state's socio-economic political circumstances. This expectation cannot be extended to mean that domestic laws will remain stagnant over time. Over here, I must point the tribunal to paragraph 3 of the factual matrix. If the tribunal is with me, I'd like to point out that paragraph 3 makes it explicitly clear that the government of Ecuador has been undergoing a massive overhaul of their public health infrastructure. This is something that they have even taken the help of from international companies. Therefore, knowledge of this upheaval was very well internationally known. Therefore, it becomes very clear that any expectation that the legal regime of the country will remain unchanged in terms of important attributes of price controls and quotas is unfounded. Therefore, the claimant should not have had any expectation of stability with regards to the respondent's regulatory framework. Coming to my second submission and my last submission of this issue, I have to put forth that the respondent has not taken any unreasonable or discriminatory measures against the claimant. An action of a state is not arbitrary only if I apologize. The action of a state is not arbitrary if there does exist a bona fide public purpose, and this was achieved through proportional means. Over here, through my previous argumentation in issue 2, this has already been established. Furthermore, I have already pointed to the tribunal how the provisions of the HEA were not targeted at the claimant and therefore are not in any way discriminatory. Therefore, we have proven to you that the FET standard as put forth in the BIT has not been contravened. We've proven this to you on 2 grounds. Firstly, that the legitimate expectations of the claimant do not exist. And secondly, that there were no arbitrary and discriminatory measures. With this, I'll be concluding my submissions with regards to issues 1, 2, and 3.
Let the claimant,
May it please the tribunal, I'm Kevin Tick, and I, along with my co-counsel, Benedict, appear on behalf of the claimant, Farmanex. I'll be addressing issues 1 and 2. My co-counsel will address issues 3, 4, and 5. Members of the tribunal, the claimant, being dedicated to public health, has invested much into producing state-of-the-art medicines and trying its level best to keep prices affordable. But the HEA has dictated their business, threatened the viability of their investment, and is now being used to justify their nationalization. At this juncture, the claimant has no choice but to bring this claim before this present tribunal. To that extent, I'll be making 2 submissions. First, that this tribunal has the requisite jurisdiction to hear this dispute because the arbitration agreement in the BIP has been effectively incorporated into the investment agreement between the claimant and the respondent. Second, that the application of the HEA is discriminatory and in breach of Article 1 of the BIP because the claimant has been treated less favorably than other local pharmaceutical companies in life circumstances without justice. Members of the tribunal, turning to our first submission, we submit that this tribunal should hear this dispute because the investment agreement has effectively incorporated the arbitration agreement in the BIT, and that the preconditions of amicable settlement have been fulfilled. The 1997 case of American Manufacturing and Trading and the Republic of Z held that the jurisdiction of the tribunal is predicated upon the consent of both the state and the investor. However, there is no need for specific consent to exist within the investment agreement itself for the tribunal to have jurisdiction over the dispute.
Counsel, can I interrupt you? Now, there has been a direction by the Supreme Court on the respondent. Is that so?
Yes, Mr. Arbitrator, there has been a
So
Supreme Court.
what do you think the implication of this tribunal's decision and the applicability of the decision within the respondent country?
Mr. Arbitrator, it is submitted that this tribunal will still have jurisdiction despite the Supreme Court's decision because both parties, the state and the investor, have consented to the jurisdiction of this tribunal. This is because the state of Equiterra would have consented by agreeing to Article 4 of the BIT. This would amount to a unilateral offer to arbitrate, which is accepted when the claimant submits its request for arbitration. And the claimant would have submitted this request for arbitration through its notice of arbitration, which can be found at page 7 of the bundle. Given that the consent between both the state and the investor is complete, it is submitted that the arbitration agreement under Article 4 of the BIT has been effectively incorporated into the investment agreement of the claimant and the respondent. Therefore, this tribunal would have the jurisdiction to hear this present dispute.
Mr. Counsel, do you think you can enforce this award if we hold in their favor, in Equiterra? Because wouldn't it cut across the Supreme Court's decision?
No, Mr. Arbitrator. No, Mr. President. It is unlikely that this will cut across the Supreme Court's decision because the Supreme Court has already ruled that the HEA should be enforced in the prior decision itself. Therefore, what the arbitration tribunal is considering here is whether there's a breach of Articles 1 and 2 of the Bilateral Investment Treaty and whether there are grounds for expropriation. It is therefore submitted that this tribunal will still have jurisdiction on these issues.
Clarification. So what you basically proposing is you should accept the arbitration without privilege in
Yes.
this case.
Yes, Madam Arbitrator, that is what we have submitted. Further, under Article 4 of the Bilateral Investment Treaty, there is a requirement for attempts to make an amicable settlement within a reasonable period of time before the claim can be brought before this tribunal itself. This can be seen under Article 4 of the BIT, which states that if the dispute cannot be settled amicably within a reasonable period, the investor may submit the dispute for arbitration. The reasonable period here likely serves the same purpose as a cooling off period in BITs, which was held in the 2008 case of Bywater and Tanzania to be the facilitation of opportunities for amicable settlements, not the impediment or obstructions of arbitration proceedings. As such, it will be satisfied so long as genuine attempts at negotiations and consultations have been made, and further periods of negotiations are proven to be futile. It is clear here that genuine attempts at negotiations and consultations have been made, albeit without result. Page 5 of the bundle, at paragraph 19, states that the impasse continued to persist even after attempts to resolve the dispute through diplomatic channels and negotiations. Further periods of negotiations would also be futile especially given how the respondent is set on nationalizing the claimant, which can be seen at page 5 and paragraph 18. Therefore, the precondition of no amicable settlement within a reasonable period of time will be satisfied here, and the claim can be heard by this tribunal.
Now, are we of the claimant, you all have not launched a claim in the local courts of Equatorial?
No, Mr. Arbitrator, we have not lodged this claim in the local courts.
Isn't the position of the respondent that without lodging a claim in the local courts, you are precluded from invoking relief under treaty?
No, Mr. Arbitrator, no, Mr. President, this will not be the case here, because the investment itself was not created illegally, and therefore the local courts have no reason to hear this present dispute. Rather, this is a claim for breaches of the BIT, of Article 1 and 2 of the Bilateral Investment Treaty, which should be heard by the tribunal.
Clarification, counsel. So you say that there is no need to exhaust the local remedies.
Yes, Madam Arbitrator, there is no need to exhaust the local remedies. Unlike the understanding under international law, investment cases only require that a precondition of exhaustion of local remedies to be expressly stated. If the requirement of the exhaustion of local remedies is not expressly stated, then there is no such requirement that will hinder or impede the jurisdiction of this tribunal.
You rely on authority for that?
Yes, Mr. President. My authority on this is the case of Bank of Mali and Bahrain, which stated that, or put forth the proposition that there is no requirement of an exhaustion of local remedies unless it is expressly stated. If the tribunal has no further questions on the first issue, this concludes my submission for the first issue. Moving on to my second submission, we submit that the application of the KPA is discriminatory and a breach of Article 1 of the BIT. Article 1, in essence, is a national treatment provision, with its aim being to provide a level playing field between both foreign and local investors. To that extent, the 2009 case of Binder and Pakistan established 3 elements to be proven before the national treatment provision can be said to be breached. First, a local comparator in like circumstances must be identified. Second, the foreign investor must be treated less favorably than the local companies. Lastly, the less favorable treatment must be without justification. We submit that in the present case, all 3 elements will be satisfied here. First, a local comparator can be identified. The local pharmaceutical companies will likely serve as relevant comparators because of 2 reasons. First, it is clear that the claimant produces medicines for the healthcare sector in Equatorial, which is fundamentally the same as the local pharmaceutical companies. And this can be seen at page 18 of the investment agreement at clause 3, which states that Pharmanex will leverage its expertise and resources to support Equiterra's healthcare system. Second, the regulatory regime in which the claimant operates in will also be the same as that of the local pharmaceutical companies. Page 20 at clause 5 of the HEA states that its enforcement is mandatory for all stakeholders in the healthcare sector. As such, the local pharmaceutical companies will serve as relevant comparators in like circumstances as the claimant. The second element of less favorable treatment would also be satisfied here. Pharmanex would have been subject to stricter pricing and quota requirements than the local companies. The reason for this is twofold. First, the claimant lacks expertise in delivering the medicine to rural areas because they do not specialize in catering to specific regional needs and niche markets like the local pharmaceutical companies. And this can be found at page 4 and paragraph 12. Second,
So don't you think, counsel, I'm sorry to interrupt you, but the respondent's action is reasonably justified to satisfy Article 1?
no, Mr. President.
Because now you just said that your company is not geared to serve the rural areas of Equatorial.
No, Mr. President. The application of the KPA here doesn't appear to be justified because it seems to be motivated, it is motivated by political pressure on the government of Equatorial to avoid being replaced. And this can be seen at page 37 of Procedural Order number 2, at paragraph 16. Page 37, Procedural Order number 2, at paragraph 16. It states at paragraph 16 that the political party in the government of Equatorial will be replaced, endangering the EIP if the HEA is not properly enforced. So it appears that the less favorable treatment here will not be justified because this is motivated purely by political pressure on the government of Equatorial.
Clarification, Council. So what do you think about because you're a multinational company and the rest of the competitors are domestic companies. So how do you think about, what is the role according to your point of view, the economic imbalance between your companies, two companies? Does it play a role in deciding the circumstances?
No, Madam Arbitrator. In this case, it is likely that they can be compared because the purpose of their medicines, their products, is the same, and that is to ultimately serve Equatorial's healthcare sector. What the difference between the local pharmaceutical companies and Pharmanex? What the difference goes towards is the less favorable treatment. And here, the local pharmaceutical companies like specialize in transporting medicines to the rural areas compared to the claimant himself. Members of the tribunal, I know that my time has elapsed. May I have an additional minute to summarize my position? It is submitted that there is less favorable treatment of the claimant here for two reasons. First, because the claimant lacks expertise in transporting these medicines to the rural areas compared to the local pharmaceutical companies due to their lack of expertise in catering to niche markets in Equatorial and regional needs. Second, because the claimant produces medicines of higher efficacy, this will naturally lead to higher costs for the claimant. And the inference here is that a fixed pricing requirement will be far more disadvantageous to the claimant than local pharmaceutical companies. Unless I need your further assistance with this tribunal, this concludes my speech.
If I could take just a minute of the tribunal's time to gather my thoughts before presenting the rebuttals on issues 1 and 2.
Yes.
If I could get the tribunal's attention. I will be presenting my rebuttals on primarily 3 grounds. Firstly, with regards to the jurisdiction issue, members of the tribunal, I must highlight that the counsel of the claimant had the burden to satisfy all of the objections that I posed with regards to jurisdiction. However, our main jurisdictional objection has gone unchallenged and unacknowledged and therefore should still stand. That being pertaining to the illegality of this investment. Anderson versus Costa Rica is very explicit in this regard. The respondent or the host country's consent to deal with investments can never be implied to mean that they have given their consent to dispute on investments that are illegal.
Counsel, can I interrupt? Why do you say the investment is illegal? Have you taken up that position previously?
Certainly, I took it up in my first issue. I clarified the investment is illegal because
I mean, factually, have you all, from the beginning of your discussion or arrangement, have you
I have.
disputed their investment?
I have. Just to clarify, this was done on the undisputed fact the investment violated the HEA, which is an applicable host state law. This was because they did not follow the fair pricing mechanisms, nor did they follow the quotas. Because this went unchallenged, this jurisdictional objection must still stand.
I think, I'm sorry, I think we need to give him a little bit of time. Your position that the investment became illegal is subsequent to the investment being made.
Certainly. Mr. Arbitrator, if I could point your attention to Article 5, they have not made a distinction that the investment must only comply with the host state law while being made. Certainly in cases where it was said that when establishing the investment, they must comply with host state laws, Mr. Arbitrator, your point would have hold more merit. However, in this case, given that Article 5 puts forth, there is a continual need of the respondent, of the claimant, to always comply with the host state's laws.
Most certainly, but my concern is, the claimant's position is that the claimant came into the country, and then subsequently, the host state changed the playing field, and now claiming that the investment is illegal.
So, Mr. Arbitrator, to this, I would like to give a quick clarification. During the negotiations of the investment prior to entering the country, the respondent had expressly put forth their commitment towards healthcare equity and to ensure distribution of essential medicines to the rural citizens of Equatorial. Therefore, the claimant must have been aware that such a regulation would have come forth. Furthermore, prior to this, Equatorial's current stat and socio-economic situation, where they were going through a public health overhaul, is very relevant because the situation in Equatorial was so turbulent with so many different laws and regulations coming up. All of this must have been expected and anticipated by the claimant prior to coming forth with their investment. And if that answers the question.
You can conclude what you were submitting earlier.
Certainly. I would like to present my last two rebuttals with regards to issue 2. Firstly, in terms of like circumstances, United Parcel Service, was the government of Canada, is very clear. Even if the two companies operate in the same business sector, if it can be proven that they operate on a very differentiating scale and size, like circumstances cannot be established. Members of the tribunal have already pointed out here that the claimant is a monopoly in this market, and as the counsel of the claimant have themselves admitted, the rest of the companies all operate to only niche interests and are very local in this regard. Therefore, like circumstances cannot be presumed in this case. Furthermore, coming to my last rebuttal, the claimant has put forth that the HEA was something that was impossible for them to comply with. However, what must be acknowledged is that the HEA was uniformly presented to every single investor in the pharmaceutical industry. Only Pharmanex was the only investor that failed to comply with their provisions. Furthermore, the claimant, as I pointed out, was fully aware of the logistical challenges they would have faced before entering into this foreign country. And beyond that, I'd like to point out that the claimant has in the past proven themselves to be very suitable in terms of delivering medicines to developing countries. I've pointed out that the World Health Organization even acknowledged that the claimant has done a fantastic job in delivering medicines to developing countries during the COVID-19 pandemic. Therefore, any failure in complying with the HEA is a personal failure on their part and not a representation of the HEA's validity.
Very well. I think you're done with your time.
Just another clarification. In the previous speech, you said that it was necessary to ensure equity in the medical field. So, by means necessary, do you think that it was the only measure, or whether there was a less restricted measures were available to hospital?
Madam Arbitrator, this was the most logical route that could have been taken by the respondent, and furthermore, this was the route that was also agreed upon by both parties when making the investment agreement. If we take just a few seconds, I could point Madam Arbitrator to the investment agreement, wherein it has been agreed upon that the claimant will have an obligation to price their medicines according to fair pricing policies, which is what the HEA has tried to implement.
Very well. we'll give you 2 minutes for your rebuttal.
Yes, Mr.
Members of the tribunal, I have 3 points to make in regards to the respondents' rebuttals. The first point is that we respectfully disagree with the contention of the respondent that we did not deal with the merits of the case. It
How
is,
do you address the issue of legality? Because they say you violated the HE.
Mr. President, we submit that the investment was not made illegally in the first place. The investment was for the provision of medicines into Equiterra to improve healthcare access and empathy there. Therefore, there is no illegality in that case.
Very good.
On our second point, we note that the healthcare equity, as stated in the investment agreement between Pharmanex and Equiterra, is not the same as accepting the application of the HEA itself. As a last point, we note that the respondent stated that the fact that Pharmanex had a 25% market share in Equiterra constituted a monopoly. We submit that this surely cannot be the case, as the other 75% of the market share is held by the other local pharmaceutical companies. This concludes my rebuttals. Thank you.
We'll go to the second round.
May it please the tribunal, my name is Benedict Wood, and I'm co-counsel to claimant Pharmanex Inc. With the tribunal's permission, I'll be taking 15 minutes in my submission and respectfully reserve 2 minutes for rebuttal. I'll be addressing the following 3 issues. First, whether the application of the HEA was arbitrary in breach of Article 2 of the BIT. Second, whether the respondent has legal grounds to nationalize the claimant. And third, whether the HEA can override the BIT. I shall now move on to my first submission, that the respondent has undermined the claimant's legitimate expectations, amounting to a breach of Article 2 of the BIT. Because of the superior nature of the claimant's medicines and their naturally higher cost, price setting ability was so important to the claimant that they expressly provided for it in the IA. I'm referring to page 18 at clause 4 of the IA. The claimant,
Clause 4.
page 18 at clause 4 of the RG. We submit that the claimant has a legitimate expectation that they can set their own prices as long as it is fair. It amounts to a legitimate expectation because it is a contractual promise by the respondent that is both specific and fundamental to the claimant's investment. And it is reasonable because it is entirely congruous with the respondent's representations at the time of making the investment. If I'm referring to page 4 at paragraph 11, of the rebuttal. Although the respondent indicated that they were going to enact the HEA, they merely emphasized the overarching goals of the HEA. There was nothing to suggest that the claimant's specific expectations that they could set prices would be subsequently undermined.
I have a clarification.
Yes.
Did this specific contractual provision encourage you to invest in the host state?
Madam Arbitrator, the fact that we expressly provided it and the fact that it directly affects the claimant's ability to profit in that investment is enough to suggest, it is enough to prove that it was what the claimant relied upon when investing into the.
So you relied upon that provision?
Yes, Madam Arbitrator. And so in totality, the respondent glosses over the specific contractual promises that they made to the claimant. And we submit that clause 4 amounts to a legitimate expectation that the claimant can set fair prices. And what a fair price constitutes is that it should reflect the interests of both parties. So while it should be affordable in line with the respondent's goal of healthcare equity, it should also give the claimant the leeway to vary costs according to their varying vary prices according to their varying costs. But we submit that by subsequently introducing fixed price lists, the respondent has curtailed the claimant's ability to set their own prices, undermining the claimant's legitimate expectations. And there is no reasonable justification because the claimant has been entirely fair in setting prices. As a baseline, the claimant's urban area prices are in conformity with the HEA. It is a price level that not only the respondent accepts, but that is in line with the market rate, despite the claimant's higher quality. And if I may refer you to page 32 of the REIT bundle at paragraph 27. The mere
52.
at clarification 27.
27.
Yes, that means yes, the arbitrator. The mere 5% premium in rural areas reflects the higher transportation costs to rural areas due to the lack of infrastructure, and is the bare minimum to keep the claimant's investments going. And in any case, 5% does not suddenly make the claimant's medicines unaffordable. And since the claimant has set their prices fairly, the respondent has undermined their legitimate expectations without reasonable justification. It is
a fundamental human right or a fundamental right in Equatorial for right of health and medicine.
Mr. President, I understand your concern that it addresses a legitimate policy, but that does not justify the respondent undermining specific promises made to the claimant. If that is the respondent's position, then they could justify undermining any of their contractual provisions just by reference to healthcare equity, which should not be the case.
And just a clarification, did these measures by the host state had impacted on your profit margins?
Yes, Madam Arbitrator, by forcing the claimant to set a low fixed price and curtailing the ability to change their prices, that would necessarily affect their profit margins.
And were there any other local companies who had also transgressed this provision of the HEA?
No, Mr. Arbitrator, but to our knowledge, no other investor or no other pharmaceutical entity had been promised the specific promise that the claimant had, which was that they could set their own prices.
Thank you.
Is there no further questions? I shall move to my next submission. That the provisions of the HEA are unreasonable, such that they amount to arbitrariness. As a matter of applicable principle, a finding of arbitrariness can be made solely by reference to the unreasonableness of the HEA's provisions. So even though the HEA may pursue a legitimate policy of healthcare equity, their measures may nevertheless be unreasonable in order to achieve that policy. And we submit that the HEA amounts to arbitrariness because the measures are patently unreasonable, and they are so onerous to the claimant that they force the claimant to operate at a loss despite the low margins that the claimant is already operating on. The HEA's provisions are unreasonable because they set the same price and the same quota regardless of the efficacy of the medicine. By way of illustration, even if the claimant produced a 90% efficacious medicine, they'd be forced to set the same price and deliver the same quota as a 40% efficacious medicine, despite being more than twice as efficacious and naturally costing more to make. Effectively, the provisions dictate the claimant's price and the claimant's quota, determining the entire business. And under this regime, even though it only targets essential medicine, it is so onerous to the claimant that if I may refer you to page 4 and paragraph 14, the claimant has repeatedly stated that just to comply with the rural area provision prices and quotas would undermine the commercial viability of their entire investment. This shows two things. It shows just how onerous the HGA's provisions are, and it shows the low margins that the claimant is already operating on. The claimant understands the importance of healthcare equity and has been trying its level best to keep prices affordable. In light of its higher costs, the mere 5% that the claimant is charging is unavoidable just to keep the investments going. But the HGA goes further than that to mandate that the claimant either operate at a loss or act in breach of the HEA. The respondent mentioned that the claimant currently is making a profit, but this is entirely because their making of a profit is dependent on a breach of the HEA, which just shows how onerous it is. So despite the policy of healthcare equity, it does not justify unreasonable provisions that dictate the claimant's business, force them to make a loss, even though they are already operating on low margins. In totality, the HEA amounts to arbitrariness. This concludes my submissions for the third issue.
Isn't expropriation contemplated for public purpose? Can't the respondent rely on that?
Mr. President, this brings me to my fourth issue, that in order to have legal grounds to nationalize, if I may point the members of the tribunal to page 14 and Article 3 of the VIT. In this present case, we are not contesting that there is a public purpose. So yes, Mr. President, there is a public purpose. But nevertheless, the language of Article 3 is such that a public purpose, a non-discriminatory basis, due process in law, and adequate compensation are cumulative requirements. This means that even if it is for a public purpose, it is nevertheless unjustified if it is on a discriminatory basis.
I have a clarification regarding your overall interpretation of the foreign treatment. Because in the bilateral investment treaties, the content has mentioned, and the content does not refer to legitimate expectation. By bringing the legitimate expectation element, are you submitting that it should be interpreted as an autonomous standard, which is different from public international law or the international minimum standard of customary international law? You suggest that it is an autonomous treatment standard.
Madam Arbitrator, although the Article 2 does not expressly provide for it, the case of Saluka v. Czech Republic held that legitimate expectations are a component under the FET standard, and it does not have to be expressly provided, and it is encapsulated under the idea of a fair and equitable treatment. And so yes, it's an arbitrator. Moving on to my fourth submission, we submit that the respondent's contemplated nationalization is discriminatory and thus does not have legal grounds to nationalize the claimant. And it is because it accords treatment that is both differentiated and unreasonable. It is differentiated because, as my co-counsel has submitted, the blanket provisions of the HEA specifically target high-end manufacturers like the claimant, forcing them to lower their prices with their low-cost, low-efficacy competitors. Effectively, they are being forced to absorb the higher costs of their better medicines. And so despite the guise of uniform treatment, it effectively accords the claimant differentiated treatment. And not only that, the claimant will be the first and only pharmaceutical entity to be nationalized under the HEA if this were to go through, emphasizing the differentiated nature of their treatment. And there is no reasonable justification because the claimant has acted in accordance with the IA. The respondent cannot point to the breach of the HEA because it is in the first place unreasonable. As submitted, it is arbitrary, discriminatory, and a breach of the claimant's legitimate expectation. Essentially, the claimants only breached the HEA because they were set up to fail. And as such, nationalization would be on a discriminatory basis. And it is submitted that the respondent has no legal grounds to nationalize the claim. Moving on to my submission to the fifth issue. The HEA cannot override the BIT. If I refer you to page 14 and Article 5 of the BIT, the HEA specifically provides that for subsequent measures like the HEA, it states that measures for the protection of public health should not be applied if they constitute arbitrary or unjustifiable discrimination. And we submit that the application of the HEA is both arbitrary and unjustifiable discrimination and thus cannot override the BIT. The respondents may point to their sovereignty to justify the HEA overriding. However, this argument only takes them so far. There is nothing in the language of the BIT that says that their sovereignty may override the BIT. And in fact, the claimant has already agreed to the provisions of the BIT, and thus they should be bound by it. If the
Council, can I interrupt?
Yes.
How do you differentiate the state's right to regulate in the context of the case of Simon Sweeney, which the respondent is relying on?
Mr. Arbitrator, if I may clarify, this goes towards nationalization. Mr. Arbitrator,
So state sovereignty cannot overrule or supersede the BIT is your contention.
yes, Mr. Arbitrator. If I may point to Simon Sweeney, my apologies, I'm not entirely familiar with the authority. But I believe that it goes towards nationalization as a regulatory taking. Would I be correct in pointing that out? We submit that a regulatory taking has to nevertheless be on a non-discriminatory basis. And as you have submitted, since it is discriminatory, it amounts to a violation of, if it is discriminatory, they will not have a basis for a regulatory taking. Members of the tribunal, I note that my time is up. If I may have a minute to summarize my submissions. Thank you. In conclusion, we submit that the application of the HEA is arbitrary and that the nationalization would not be justified because it is on a discriminatory basis. And the respondents cannot swing their sovereignty around to ignore the provisions of the BIT, which they have already agreed to. If the tribunal has no further questions.
I may have a question.
Yes.
Yeah, it's like, I got your point that you're telling that the legality, the conditions of legality of expropriation is not met here, that's right.
Yes,
So what is your take on whether the expropriation has taken place or not?
Madam Arbitrator.
So my specific question is, do you believe that these measures has substantially deprived your investment?
Madam Arbitrator, we submit that the respondent is only contemplating nationalization. And short of that, we have not yet been expropriated. What we are seeking is that the tribunal give an opinion that nationalization would be discriminatory and thus would not be justified.
Because it's has not been taken place yet.
Yes, Madam Arbitrator.
Thank you.
Thank you.
Greetings to the members of the tribunal. I, Lanka LSASL, in the course of next 11 minutes, will represent the respondent, Government of Ecuador, in issues 4 and 5. In regard to issue 4, which deals with the lawfulness of expropriation, I have primarily two submissions to make. Firstly, that the claim of expropriation is preemptive and thus not valid. And the second one, that expropriation is a lawful and a valid use of police powers and therefore is lawfully being conducted under the BI. Starting with my first submission, I would like to submit that an expropriation claim comes into existence only when the expropriation is enforced and mere threats of expropriation or nationalization are not sufficient to make a claim. This has also been held in Glamis Gold versus United States. I would also like to submit that my respected opposite counsel could not form a prima facie case according to the Unilateral Rules number 26, which states that to claim an interim award like the injunction claim in the present scenario, a prima facie case first has to be established. The conditions of a prima facie case are that first, an injunction can only be claimed if there is an irreparable harm that is being caused by the expropriation. However, in the present scenario, expropriation in this scenario is not a harm that the respondent is trying to cause to the claimant. It is in fact a penalty measure. It is a penalty measure because of they are not compliant with the HEA. And in the export of HEA that is provided in Annexure D, found on page 20, it is already given that measures that nationalization can be taken if HEA is not complied with. Furthermore, the claimant themselves have submitted and asked for compensation. This means that respondent can repair the damage that has been caused to them. This means that it is not an irreparable harm that has been caused to them. Secondly, a prima facie case can be established if they prove that the expropriation was not for public purpose, was in a non-discriminatory manner, did not follow due process, and were not given compensation. However, through the course of my second submission, I will be dealing with all these four issues. If the members of the tribunal do not have further clarifications, I would like to move on to my second submission.
So I have clarification. What you mean is that since the expropriation has not been taking place, so that is if it is going to be happen, it would be an outcome of the clement investor is not following the domestic law.
Yes, Madam Arbitrator. If I could point, Madam Arbitrator, to Annexure D of the MOVE proposition given on page 20. Point number 5 very clearly states that non-compliance may result in legal action and penalties, which may include nationalization. I hope that satisfies you.
Yeah, it's clear.
Thank you. Starting with my second submission, I would like to submit to the tribunal that expropriation in the present scenario, if materialized in the future, will be lawfully conducted as per Article 3 of the BIT, which mandates that an expropriation should be done in public purpose, in accordance with due process, in a non-discriminatory manner, and should be accompanied by an effective, prompt, and adequate compensation. Starting with my first condition, I would like to submit that maintaining public health is a primary basic duty of the government, and the same has been recognized in Article 12 of the International Covenant on Economic, Social, and Cultural Rights, to which we, the respondent, are a signatory. Moreover, public purpose includes public health. This has been established in the case of Philip Morris versus Ukraine in paragraph 291. In such matters, which are as critical as the public health, the states have a right to determine the country's interests, even if it affects private entities. The HE in the present scenario was also adopted to address these healthcare disparities, and the reason to contemplate expropriation was only to control the pricing and distribution of essential medicines, because as my co-counsel had already pointed out, there are more than 3 million people of Equaterra who are still not receiving essential medicines. Now, I would like to start with my second condition, that the contemplation of expropriation has been done in accordance with due process. Members of the tribunal, the criteria of due process of law establishes that the parties should follow all forms of procedural fairness. This includes that the respondent should give a proper mechanism to the claimants to come forward and give means for a legal address. In the present scenario, I would like to point to the tribunal that investor has the recourse to approach domestic courts or the administrative tribunals. However, in here, the claimant itself did not pursue these avenues to challenge the measure. This can also be seen on para 19 of the factual diagram. They themselves refused to go to the local courts, even though the respondent did provide them with the window to go to the local courts.
Is that a prerequisite to come before this tribunal?
Uh, Mr. Arbitrator, I would like to point out that once the negotiations failed, the claimant had the opportunity to come to this tribunal. However, what I am contending right now is that due process had been followed by the respondent. This is because we gave them the opportunity to come to the domestic courts. So there was no disregard from the respondent's part.
I'm sorry, I didn't follow you. Can you repeat that?
Mr. Arbitrator, what I'm trying to submit is that there was no disregard of the due process of law. This is because due process amounts that respondent should give the claimant a window to approach legal mechanisms. The respondent in the present scenario did give the claimant the window to approach local courts. However, the claimant themselves decided that they did not want to recourse to those legal avenues.
But does due process only mean the opportunity of going to a local court, or the respondent, that is the host state, following the process of law as established in the process of expropriation?
Mr. Arbitrator, to that I would like to submit that since expropriation has only been contemplated in the present scenario, there is as such no obligation to continue with a prescribed mechanism of expropriation. When the expropriation will actually be taken place, that is, when formal actions will be taking place, the respondent does guarantee to make sure that it follows all prescribed mechanisms. However, till now, expropriation has only been contemplated.
For the clarification, if they approach the domestic courts, don't you think that it creates a fork in the road to approach the international arbitration? Create some fork in the road clause, like if that, like how so that it's
That
like
it
a,
splits,
yeah.
that if you take this road,
If you
you
take
end up in
this
the
road,
domestic
end up
system
with-
only.
Madam Arbitrator, I would like to submit that fork in the road clause is something which needs to be specifically mentioned in the BID. However, in the present scenario, the BID does not mention any clause which relates to fork in the road clause because it is very clear that if the negotiations fail, then they have a proper mechanism and they can approach the arbitral tribunal.
Yeah.
So just now, my concern here is you have not expropriated. So you at one breath say that in the future when you do something in that regard, the claimant will have an opportunity of going to the local system. At the same breath you say that the claimant should not have come before this tribunal also. Isn't that anomalous?
Mr. Arbitrator, what I was trying to submit is that the respondent did not hinder the claimant's opportunities to a legal address. This is what the contention of due process is, that we should not be hindering their chances of any legal mechanism.
Understood, thank you.
Due to the paucity of time, I would request the tribunal to grant me an extension of 2 minutes.
Very good.
I would now like to move to my next condition, that expropriation was not done in a non-discriminatory manner. As my co-counsel had already submitted, the investor was subjected to different treatment with a reasonable justification. This is because I would like to point to the tribunal that PharmaNex in the present scenario is the only company that is breaching the HEA. According to clarification 15, there are no other companies which are in dispute with the respondent. This is why the contemplation of expropriation has only happened against the claimants, this makes our contemplation of expropriation reasonably justified. Moreover, we have not discriminatorily treated the farmer nets because we have made sure that the provisions of the HA are applicable to all pharmaceutical companies without any exception. We have not created any less favorable condition and made sure that all companies in the sector have a level playing field. I would now like to move on with my last condition. That is, that the expropriation will be accompanied, if materialized in the future, with adequate, effective, and prompt compensation. Members of the tribunal, I would like to submit that the respondent can lawfully expropriate the claimant on payment of a prompt, adequate compensation. In the present scenario, compensation was discussed with the claimant. This can be seen in clarification number 1, procedure order 3, given on page 44. The presence of negotiations in determining compensation indicates good faith. This shows that compensation was never denied from our side. We are still in the process of negotiating it. Therefore, we are not saying that if the expropriation is materialized in the future, we will not be providing them with compensation. The fact that we have already discussed the compensation shows that we are actually in good faith and making efforts that we are able to repair the harm. If the tribunal does not have any further questions, I would like to sum up my last speech.
No question, clarification. So when it comes to a justification, are you rely on policy power doctrine in customary international law or the NPM clause in the clause 5 in the bilateral investment treaty, or both?
Madam Arbitrator, due to the paucity of time and the contentions made by my opposing counsel, I will for now only dealing with the clause that has been given in the BIT, which is article number 5. I would like to submit that an investment has to remain in accordance with the domestic laws throughout the course of the investment and not just the beginning. It needs to be pointed out that the BIT provides protection to investors only if they are in compliance with the domestic laws. It does not provide protection when the investors do not comply with the host state's law. The claimant over here did not throughout comply with the investment agreement or the domestic laws. They were not complying with the H rate. They followed their own pricing mechanism, and they also did not comply with the quotas that were provided in order to make sure that needy people get access to the essential medicines. I would also like to submit that the claimant cannot claim that they did not know when the HA would be applied. This is because an investor has to anticipate the circumstances, and these circumstances can change. When the claimant made their investment in the government of Equiterra, they were very well aware about the situation in which Equiterra is prevailing in. There were 3 million people which were not having essential medicines. The country was in a turmoil and trying to overhaul its healthcare security, its healthcare access, which is why no assurance can be made that the government will not take any measures to protect its citizens. The claimant was aware that there will be potential changes in the legal environment to make sure that healthcare equity is maintained. With that, I would like to come to an end of my submissions and submit that since the claim of expropriation is still contemplating, it is not valid, since claimant has not complied with Article 26 of the UNCITRAL rules, and expropriation is contemplated in the future will be done on a lawful basis.
Just a clarification, what your last point, answer. So the last point is the investor was not diligent. That was its point.
Yes, Madam Arbitrator, due diligence has to be adopted.
The other clarification is, so you mentioned the Philip Morris versus Uruguay case where, and which very clearly mentioned the proportionality aspect as well. So do you think that your measures, if the expropriation is going to be completed in the future, what is your stake on the proportionality element as well?
Madam Arbitrator, and I had already submitted, while discussing the condition of non-discriminatory clause condition, I had submitted that since claimant is the only company that is breaching the application laws of fair pricing mechanism and quotas, it becomes proportional that we are contemplating expropriation only against them. Furthermore, expropriation was the only method or measure that could be adopted in this present scenario. Imposing more trade restrictions or penalties would not guarantee the respondent that the claimant will actually comply with the fair pricing mechanisms, as HEA itself was a regulatory mechanism, and the claimant went ahead and breached it. Therefore, imposing more trade restrictions does not give a guarantee to the respondent that these laws will be followed. Also, just by making sure that the claimant pays a sum amount as a form of penalty, we cannot assure that in the long run, the needy people of Equiterra will actually have access to the essential medicines.
So it means that the expropriation, if it is going to be happen, this is the last resort.
Yes, Madam.
Is there any reason or cause why the state, the whole state is off the rail that expropriation is the only solution and something less wouldn't do? Are there regulatory measures?
Certainly, Mr. Arbitrator, and I had already pointed out to the question of Madam Arbitrator, other least restrictive measures may include imposing more trade restrictions or imposing penalties and fines on the claimant. However, in the present scenario, HEA itself was a regulatory measure. Imposing more regulatory measures would not guarantee that the claimant will not go ahead and breach those regulatory measures like they already breached the HEA. Imposing penalties is not going to help us fulfill our purpose of making sure that needy people get access to essential
Does
medicine.
the HEA have penalties?
Yes, Mr. Arbitrator, as I had already pointed out, in point 5 of the HEA, it has been given that non-compliance of HEA may result in penalties like nationalization.
Extreme, but okay. Thank you.
Members of the tribunal, the respondent has made 2 points which I will contend. Essentially, the respondent's position is that they want to have their cake, so they want to eat their cake and have it as well. On the point of overriding the BIT, they say that the breach of the BIT, a breach of the HEA prevents BIT from protecting the investor. But taken to their logical end, they could introduce onerous provisions subsequently, such that the investor is in breach of the provision and that the BIT no longer protects them. Such is a preposterous position. On the point of the due process in nationalization, the respondent submits that they have accorded us due process, but only if we go to their local courts. It is evidenced by these proceedings today that the respondent has also attempted to refute this tribunal's jurisdiction to hear the nationalization claim. And not only that, the respondent is immediately contemplating nationalization just because the claimant has not complied with their pricing and quota mechanisms. They have less drastic measures that they could employ, but they have chosen nationalization as a first penalty, which highlights the unreasonable nature of the contemplated nationalization. And in any case, and this highlights the draconian nature of the claimant's action, that the claimant only has recourse if the respondent decides. As such, we submit that this nationalization is discriminatory and unreasonable, and that the HEA cannot override the BIT. Thank you.
If I could just take 30 seconds to gather my thoughts.
I'm reserving 2 minutes for my just now you said I had time's up, but I had reserved 2 minutes for my rebuttal. So I apologize if there was any miscommunication.
I would like to answer my opposing counsel's first rebuttal by saying that there is no onerous obligation on the claimant. This is because the claimant is already a profitable company and it does not lack any expertise. The claimant in this scenario is a world-renowned company that has already been stated as the savior of the world. Therefore, it needs to make sure that it does not lack on providing accessible essential medicines to the needy people. In regard to the rebuttal placed that Article 5 of the BIT will stop protecting the investments as soon as they do not comply with the local laws, I would like to clarify that this is been based on an authority of the case of LSASL, which states that as soon as the country does not comply with domestic laws, the protection provided in the BIT does not cover them. I would also like to contend that in regard to due process, which were being rebutted, I was not submitting that due process, since we have provided you with a legal address, the due process has already been fulfilled. In ADC versus Hungary, it was held that due process also requires that a notice of intent be provided. However, in the present scenario, since contemplation has only happened and no formal action has been taken place, international law does not prescribe that a notification be given before the event has taken place. I would also like to mention that amidst all the clarifications and the signing of investment agreement that was going on, the respondent has made it very clear that HEA might come into existence. The claimant was well aware about HEA coming into force, and HEA already mentions that nationalization can be one of the penalty measures that can be taken against them, which is why the claimant cannot contend that this was arbitrary or against expectations. Thank you.
Thank you so much, team. Just step out there, move so that the judges will go. Oh. Thank you.
Thank you very much. All the very best.
Thank you.
That is just more than you want to score. That is important.
Thank you.
Thank you.